We are going to start by looking into what Canada exactly means. When you say the word Canada, what are you expressing? Many individuals think that when they say the name Canada, they are talking about a territory and a parcel of land. This, however, is not the case. When you look into the Constitution Act of Canada, 1867, Article 91, you find the following written there. It shall be lawful for the Queen, by and with the advice and consent of the Senate and House of Commons, to make laws for the peace, order, and good government of Canada. How many of us really understand what is being declared in this simple statement? Government of Canada. What exactly is a government? A government is simply the structure of principles and rules determining how a state or organization is regulated. An organization through which a body of people exercise political authority, the machinery by which sovereign power is expressed. When we use the term government, we are simply referring to a structure of rules and principles that a body of people exercise authority. A government is a group of individuals who exercise controlling power. And again, when you look into black laws or into legal dictionaries, governing body, a government, a group of especially corporate officers or persons having ultimate control. The board of directors is the governing body of XYZ Incorporated. So when we use the term government, we simply mean a body of people, a group of people, exercising power and authority. And the government is expressing the sovereign power. And in this case, the sovereign power is Her Majesty. Because here it says it shall be lawful for the Queen, by and with the advice and consent of the House of Commons, to make laws for the peace, order, and good government of Canada. So it's lawful for Her Majesty to make laws for the peace, order, and good government of Canada. We are seeing that a government is nothing more than a group of individuals exercising ultimate control, exercising power over how a state or organization is regulated. The following question then arises. What type of power is being exercised by the government in Canada, and why would I have to listen to or submit to this power? To find the answer to this question, we have to first find out exactly what Canada refers to or designates in that statement. When we see in the Constitution Act 1867, Article 91, it talks about the good government of Canada. So what is this government of Canada? What does it mean legally? When we look to the Supreme Court of Canada and the definition of this word, we find the following. Further, although Section 91.1 gave the Queen the power, with the advice and consent of the Senate and House of Commons, to alter the Constitution of Canada, except in certain expressly designated areas, it does not confer a power to amend the BNA Act. The word Canada in Section 91.1, which we were looking at, does not refer to Canada as a geographical unit. It does not refer to Canada as a territorial position, as a landmass, but refers to the juristic federal unit. And a juristic person is an artificial person under law. We know that an artificial person is an entity such as a corporation that's created by law and given certain legal rights and duties of a human being. It's a being, real or imaginary, who for the purpose of legal reasoning is treated more or less as a human being. So when we look at the word or at the statement Government of Canada, what is actually being referred to is not the landmass, but an artificial entity, an artificial corporation in law. The Canada being spoken about and brought forth in the Constitution Act of 1867, Article 91, is a corporate body, and we, as inhabitants, are being incorporated into this corporation. Since we can clearly see that Canada is a corporate body, we should be able to find subsequent evidence of this fact when Canada and its controlling powers are mentioned within domestic law. When we look to the Constitution Act of 1867, Article 9, we find the following. The executive government and authority of and over Canada is hereby declared to continue and be vested in the Queen. In the Constitution Act of Canada, 1867, Article 10, The provisions of this act referring to the Governor General extend and apply to the Governor General for the time being of Canada, or other, the Chief Executive Officer. So we saw here it's an executive government and the Chief Executive Officer. So now we're qualifying and we're seeing exactly what type of powers are in operation within this artificial person. They're talking about executive powers. Goes on, or administrator for the time being, carrying on the government of Canada on behalf and in the name of the Queen by whatever title he is designated. Now, when you look into legal dictionaries, such as Blacklaw's 7th edition, you will find Chief Executive Officer, and it means a corporation's highest ranking administrator who manages the firm day by day and reports to the board of directors. We just saw that the Supreme Court of Canada declared that Canada is a corporate body, a federal juristic unit. And when we look to the type of power in operation, we find that it is corporate powers. Canada, the corporation, the Queen has executive powers, and these executive powers are passed on to the Governor General. Again, Canada, the corporation, the officers are executing executive powers. This is corporate in nature. When we look into the enactment which governs and controls the Governor General of Canada, we find that the executive powers that he is operating on behalf of the Queen are flowing through the fact that this corporate body is a corporation sole. Office of the Governor General, corporation sole. The Governor General of Canada, so the executive power of the corporate body, Canada, or other chief executive officer or administrator carrying on the government of Canada on behalf and in the name of the sovereign by whatever title designated is a corporation sole. Canada is a federal juristic unit. The Governor General is the chief executive officer of this corporation sole. The corporation sole is called Canada, and it belongs to Her Majesty. When we look in Article 9, it says the executive government and authority of and over this corporate body, this federal juristic unit, is hereby declared to continue and be vested in the Queen. She's the big chief, and then that power, that executive power, is passed on to the Governor Generals, who subsequently will pass on these powers to ministers and lieutenant governors across our provinces. The Governor General is the Chief Executive Officer of Canada, and he controls what transpires in this corporation on behalf of Her Majesty. He also shares this power with the lieutenant governors of the province. In the Constitution Act of 1867, Article 14, we find the following. It shall be lawful for the Queen, the head executive power, if Her Majesty thinks fit, to authorize the Governor General, from time to time, to appoint any person or any persons jointly or severally to be his deputy or deputies within any part or parts of Canada. And what Canada are they talking about here? They're talking about the federal juristic unit. They're talking about the corporate body. And in that capacity, to exercise during the pleasure of the Governor General, which just means that there's no set date limit that the individual works at. When you see this expression, the pleasure of the Governor General, it means that the position that the person is occupying, there's no start date and there's no finish date. Such of the powers, authorities, and functions of the Governor General as the Governor General deems it necessary or expedient to assign to him or them. So the Governor General and the Lieutenant Governors are operating the executive powers of the Queen for the Corporation of Canada, and subsequently they transfer part of these powers to the ministers of the government. If you want to open up a company to pursue, earn, and gain a living, it is the Lieutenant Governor in Council who will allow you to open up a company under the strict control and governing powers of his executive position. The Corporations Act of Manitoba. Minister means the member of the Executive Council. There you go. You see the powers that are in operation again. They're corporate in nature and they're executive. The Executive Council charged with the Lieutenant Governor in Council with the administration of this Act. and refusal by the director. The director may refuse to issue a certificate of continuance, and in that case he shall advise the body corporate of his refusal, and the body corporate may appeal to the director's decision to the lieutenant governor and council, whose decision is final. So here, if you want to open up a corporation, if you want to open up a company, it's actually the lieutenant governor in council through his minister who allows you to incorporate your corporation. Now you think that you own the corporation. You think that you're the head executive power of your corporation, but that's not the case. In the law, what is transpiring is that the lieutenant governor and council, he's the head executive of your corporation. So if you own a restaurant, for example, you've opened it up, you're working, you own that restaurant, you get a knock at the front door. Then that guy comes in, he says, I'm a safety inspector. I've been sent from the government to inspect your corporation. What has transpired in law is the lieutenant governor and council, through a statutory power, an enactment, is exercising his executive powers over you. And he is sending the inspector to verify the state of your restaurant, to make sure it's in complying with his obligations that flow through the enactment. If you tell the guy, take a hike, you're not welcome here, he will try to fine you or eventually try to shut you down. So in the essence of it, you do not have complete corporate control over your corporation. You are not the top of the chain, as to speak. It is the lieutenant governor and council, through the ministers, who are the head executive officers of your corporation. And this ties in also with the Income Tax Act, because when you understand, under the ITA Act of Canada, they are declaring that you are operating in an office as an officer of Canada. Well, if you own a corporation and you are under the Executive Council of Her Majesty, and they are the head of your corporate body, you are operating on their behalf. And this works out in many different ways. Whatever industry you are involved in, depending on the corporation that you have opened up, the Lieutenant Governor and Council will subject your corporation to their rules and regulations. At the end of the year, you must send a report to the Lieutenant Governor and Council concerning how much income this company has generated and the like. Now, if the director refuses to issue you a certificate of continuance, he can say, no, I'm not allowing you to be a corporate body anymore. So just by that fact, if he can deny you the right to exercise as a corporate body, it shows you who has full control over this situation. So when you look to the municipal assessment enactment, we find the same thing. The minister who is in control of this enactment, who regulates this enactment, means the member of the Executive Council. So he's a member of the Executive Council, and he's exercising executive powers. When you look into Ontario Housing Services Act, it says the minister means the Minister of Municipal Affairs and Housing, or such other member of the Executive Council, as may be assigned the administration of this act under the Executive Council Act. So here you go. Again, they're exercising executive powers within the corporate body called Canada. The Colleges Act, same thing. Minister means the member of the Executive Council. Health Services Act, minister means the member of the Executive Council. We are seeing that the governors, ministers, are the ones who are operating the executive powers for the corporation designated Canada. In the Crown's statutory instruments, it is being declared that I and my fellow men and women are being incorporated into Canadian provincial corporations and therefore are executing a residence within the corporation. When you look to the Ontario Municipal Act, it states a municipality means a geographic area whose inhabitants are incorporated. Municipality Act, again, in this act, a reference to municipality is a reference to the geographical area or to the municipal corporation as the context requires. Body corporate, the inhabitants of every municipality are incorporated as a body corporate. And again, municipality means the geographic area whose inhabitants are incorporated. When you look to the city of Vancouver, corporation and boundaries. The inhabitants of the area, the boundaries of which are described in this section, shall continue to be a corporation and a municipality with the name of City of Vancouver. When you look to the New Brunswick enactments, same thing. The minister shall administrate this act and may designate persons to act on his behalf. The inhabitants of the cities and towns in existence on January 1st, 1967, continue to be bodies corporate. The inhabitants of a municipality created under this act are a body corporate under the name prescribed for it under this act. So right across Canada, in the different provinces, what is transpiring in law is that we, as inhabitants of the geographical landmass of the territory of Canada, are being incorporated into the corporate body called Canada. Nova Scotia Municipal Act, again, every municipality incorporated. The inhabitants of the county of Cape Breton are and continue to be a body corporate. The inhabitants of the county of Queens are and continue to be a body corporate. The City of Winnipeg Charter, City continued. Article 8. The City of Winnipeg, as constituted immediately before the coming into force of this Act, is continued as a body corporate. The last one here, the Municipal Affairs Administration Act. This happens in Manitoba. In this Act, minister means the member of the Executive Council charged by the Lieutenant Governor and Council with the administration of this Act. And a municipality means any locality, the inhabitants of which are incorporated and continued under the authority of the Municipal Act, the Local Government Districts Act, or any other act of legislator, and includes a rural municipality, an incorporated city, town, or village, and a local government district. So what is transpiring here? The municipality is considered a body corporate, and the inhabitants are incorporated into this body corporate. The municipality is a body corporate, and it is exercising executive power. It's the executive council over those who are incorporated into the corporate body. When you look into Black Laws, the 5th edition, the word incorporate, to create a corporation or to confer a corporate franchise upon certain persons. So they give you the franchise, they give you the role, the title, the designation of officer within this body corporate. Incorporation, the act or process of forming or creating a corporation. Canada is a federal juristic unit, an artificial person. We know it's a corporate body, exercising corporate powers, exercising executive powers, and has a chief executive officer. Further, the municipalities in the provinces themselves are incorporated under or into this corporation, and the inhabitants, such as men and women who are on the landmass, are then further incorporated into the body corporate through the local territory where they are living. The municipality, the inhabitants, are conferred a corporate position. They become an officer of the corporation. Now again, this is tying in with the ITA Act of Canada, with the Income Tax Act of Canada. Why? Because when we understand and we see who's being taxed, it's residents of Canada who are being taxed. And the withholding is being applied against the office and officers of Canada. And how do we obtain this position is through this incorporation that you are seeing here. Wherever you are living, you are being considered to be incorporated. You are conferred a franchise of incorporation into the local body corporate that is your municipality. And as such, you are then considered an officer operating in an office. Now, you don't really have any duties or responsibilities. You may be operating in an office because you've been incorporated, but you're not receiving a paycheck. However, what's transpiring is the local municipalities are using the enactments and government created regulations to rule and restrict your actions and your rights. And they are claiming the operation of law to do this is the fact that you are indeed an officer of the corporation. And as such, you owe the obligation to the enactments, to the regulations. And that's how they are enforcing their enactments against you. What is transpiring through these enactments is contrary to our fundamental rights and freedoms, our natural rights. The executive, legislative bodies are forcing us into recognition as a class of person, incorporating us into the corporation without our consent or knowledge. When we look into the international law, International Covenant on Civil and Political Rights, Article 8.2, it says no one shall be held in servitude. In Article 16, it says everyone, men and women, has the right to recognition everywhere as a person before the law. We are being forced to play a role and enter into recognition as a class of person, an officer of the corporation, before the law, which is contrary to our natural rights and freedoms. The executive legislative body have an obligation not to limit or abridge our rights and freedoms. As a man or a woman, you have natural fundamental rights and freedoms. Now, these fundamental rights and freedoms are expressed through international law, and here in Canada through the Constitution Act, more specifically through Article 7 and Article 26. Your natural rights, your fundamental rights, when you stand under them, this is what you call your full legal capacity. You're not operating as a class of persons limited under an enactment, under a regulation, but you're operating and standing under your full legal capacity with all your fundamental rights and freedoms. Now, in this capacity that I'm bringing forth and explaining to you, that is called your full legal capacity, you have the right to enter into recognition as a person before the law. You can decide that I will play the class of person. I will enter into that recognition, and I will be controlled or regulated through an enactment or regulation. Now, what we have seen tonight in this video so far about the fact that Canada is a corporate body and that the lieutenant governors and the governor and the ministers are exercising executive powers within this corporation, and that we, as men and women, have been incorporated. We have been given corporate franchise. We have been placed into this body corporate as officers of the corporation. And that is the mechanism that they are using to regulate us. Now, this goes against our full legal capacity. This goes against our fundamental rights and freedoms as preserved for us in international law and through the Constitution Act, Article 7 and 26. We are being forced to play a role and enter into recognition as a class of person, the officer, before the law, which is contrary to our natural rights and freedoms. The executive legislative body have an obligation not to limit or abridge our rights and freedoms. And here's a court case, DeVito versus Canada. Canada's international obligations are relevant principles of international law are also instructive in defining the right. The content of Canada's international human rights obligations is, in my view, an important indica of the meaning of the full benefit of the Charter protection. I believe that the Charter should generally be presumed to provide protection at least as great as that afforded by similar provisions in international human rights documents which Canada has ratified. So here the court is speaking, and they're saying that we understand that Canada has an obligation to international rights and freedoms, and that the Charter should afford us, individual men and women, the same amount of protection that is enumerated and listed in international law. And when we look into international law, we find that we have a right as men and women. And that right is we can decide if we will take recognition as a class of person before the law. And if we take recognition as a class of person, then we give up our full legal capacity and we operate through the enactments and regulations that are controlling that class of person. And here, through their enactments and regulations, they're forcing us, the inhabitants, the men and women, they're forcing us to be a part of their body corporate. And they're giving us corporate franchise. And they're calling us officers of this corporation. That's the class of person that we are. That's the class of person that we are designated in law. And since we are that type of designation, that class of person, then they come against us and they say, you owe a duty to the enactments. You owe a duty to the regulation. Why? Because as that class of person, who is the officer of the corporate body, he owes the obligation. And that's what they're doing to us. That's exactly what they're doing to us. The executive and legislative powers, the ones who are creating these enactments and regulations, cannot just simply point to the enactment and regulations and claim the ground or standing that they have the right to force us through the color of law, through the enactment, to enter into recognition as a class of person or that officer. When you look at another court judgment here in Canada, National Corn Growers Association versus Canada, it says, thus ministers, agencies, and administrative tribunals would have to be able to justify their actions by pointing to specific legislative authority in the same way that a citizen would have to be prepared to show that his or her acts were lawful. And in Zinger versus the Queen, it states it is a recognized principle of international customary law that a state, Canada, may not invoke the provisions of its internal law, its enactments and regulations as justification for its failure to perform its international obligations. So they want to come at you and they want to say, well, we have an enactment, sir, municipality enactment, local government enactment, and all other enactments. The Lieutenant Governor has said we have the right to incorporate you as inhabitants into this body corporate. You see, we have enactments, sir, and we have officers who will enforce these enactments against you. However, by doing that, what they are doing, they are pointing to internal laws. They are pointing to domestic laws, and they are saying you have an obligation to obey these laws, but in doing so, they are failing. They are failing in their obligation to allow you to express your full legal capacity before the law. Their enactments are stripping you of your full legal capacity, and they are forcing you to enter into recognition as a class of person. And by doing so, they are limiting your natural rights and fundamental freedoms. And the courts have already ruled they're not allowed to do that. The Supreme Court, okay, has already said they're not allowed to do it, but they still do it. Why? Because the way the system is set up, the only one that can free themselves from this garbage is yourself. The only one that can go in and get a remedy against what is transpiring against your natural rights and fundamental freedoms is the individual himself. And the individual must learn first international law, domestic law, constitutional law, understand they're being limited and abridged, and then they have to learn the court system, how to operate, seek the administration of justice, what's the rule of law here in Canada, and so forth. So they've made it very, very hard. They said, sure, we will respect natural rights and fundamental freedoms, we will respect them. We'll make a way for men and women to walk upon that path. And then they put 55-foot walls that are 100-foot thick. And then they put tons of gates around these walls and locked it with a whole bunch of locks and said, if you're going to get through it, oh boy, it's going to take you some time. These statutes and regulations that are being created must respect the obligations that flow from the Constitution Act of 1982 and subsequently from the covenants themselves. And again, in DeVito versus Canada, it says that more recently in Health Services and Support, another judgment, Association versus British Columbia, it confirmed that the Charter should be presumed to provide at least as great a level of protection as is found in the international human rights documents. And again, in Nemeth versus Canada, I also accept, of course, that where possible, statutes should be interpreted in a way which makes their provisions consistent with Canada's international treaty obligations and principles of international law. So the courts are saying they understand that international law and the Charter protects our rights, and it provides us the protection that is found within those international documents, and that the courts should try to interpret statutes and regulations which makes their obligation consistent with the international treaties. However, when you walk into court, the minute you walk into court, the judge is under a presumption. It is presumed in R versus Hape that the legislators act in compliance with Canada's obligations as a signatory to the international treaties. So the judge himself, when you are there, is under the presumption that the enactments and regulations, they conform to international law, they respect your full legal capacity. They conform to the charter, they respect your full legal capacity. And you walk in there and you're saying, I have a problem because there's enactments and regulations that have breached my charter rights. There are enactments and regulations that have removed my full legal capacity and have restricted my right to operate here on this landmass in Canada. And what you are saying is that by being incorporated into the local municipality, into the corporate body, they violated your international law in Article 16 and Article 8. And they violated your right to make your own decision under Article 7 of the Constitution Act, your right to liberty. But the judge's presumption is, well, no, these enactments and regulations, they conform to international law. So it's up to you to walk them through it. So the principle of justice is what? It says international law starts in Article 16. It says, I, as a man or a woman, I have a right to take recognition everywhere as a class of person before the law. It's my decision if I want to enter into recognition as a class of person, or do I want to remain in my full legal capacity under my fundamental rights and freedoms, under my human rights and freedoms. That's my decision. And further to that, Canada, you had the obligation to transfer this right into domestic law. And you can find those principles in the International Covenant on Civil and Political Rights under Article 2.2 and Article 5. So here's my right, and this right has to flow into domestic law. And they safeguarded this right. They allowed the expression of this right to come forth in the Constitution Act of Canada, Article 7, where it says everyone has the right to life, liberty, and security of the person. That's where this right, particular one, was safeguarded for us. However, when we go into the enactment has removed this right from us. Why? Because they have incorporated us, they have forced us to take recognition as a class of person, as the officer of the body corporate, and we didn't have a choice. And that action that the legislators did through this enactment and regulation, that breached our international right. That breached our charter right. And they don't have the right to do this to us, even though they're doing it. If you catch them and you call upon what they are doing, then this is the expression of Article 24 of the Constitution Act that says anyone whose rights have been limited or abridged, contrary to the Constitution, can apply for a remedy. And hang on, you just did that to me. I have an international human right. That human right says I can stand in my full legal capacity, or I can operate as a class of person. Now, the other side, the ones who are ruling over you right now, by doing this to you in the law, would want you to think and have placed a thought in you that said, well, this needs to be done. They have to have power to rule for safety and, for public good and public law. That's the way it is. But look what the courts have declared in R versus Haynes, 1999. Prior to the Charter's advent, what we're speaking about now, prior to this Charter being given force of law in 1982, the individual, the man or the woman, you and me, really had no special means of protecting against incursions upon his or her basic fundamental rights by executive or legislative arm of the state. The law and the Constitution points out at page 42 that it hinges the existence of public order and it mandated compliance with directives and ordinances, even if they infringed upon individual fundamental rights and freedoms. So before the Charter was given force of law in Canada, the operation of law was that law exists for public order, and we, as individual men and women, were expected to surrender our natural rights, our fundamental rights and freedoms for the public good. And there was no real mechanism in law for us to defend against incursions of our fundamental rights and freedoms. So when we see and understand that we have a natural fundamental right and freedom that is expressed already in international law, where it says everyone, a man or woman, can take recognition as a person before the law. Prior to the Charter, they could limit and abridge this. They could say, we're creating an enactment and we're forcing you to take recognition as a class of person. For the public good, we're going to force this upon you. And we couldn't do nothing. They would limit this fundamental right and freedom, and there was nothing we could really do because law, the creation of it, said it's for public order, not for the expression of individual fundamental rights and freedoms. But this was changed in 1976 in international law when our human rights were protected, and in 1982 here in Canada when the new Constitution Act was brought forth. And the courts has said a primary purpose of the Charter was to change this relationship of the individual with the state and its laws by endowing or giving individuals an effective means of challenging acts of the state in courts on the ground of violation of their constitutionally protected rights and freedoms. No more is the state allowed to create enactments and regulations like you're seeing here in this video tonight that strip you of your fundamental human rights and freedoms. No more. They still do it because we're ignorant to the fact of what they're doing and we're ignorant how to enforce our rights. So they do it. But in law, they're not allowed to anymore. And when you catch them and when you understand what's going on, you can get a remedy. You can exercise your full legal capacity. But they're banking on talking about fundamental rights and freedoms, human rights and freedoms, versus playing the capacity of a class of person that is limited or restricted through an enactment or regulation. Tonsum Newspaper Limited versus Canada. While individuals, men and women, as a rule, have full legal capacity by the operation of law alone. That's the rule of law. That's what it states. It's not a rule created through enactments or regulations. It's a common law rule, common law expression, that men and women have full legal capacity. Artificial persons are creatures of the state and enjoy civil rights and powers only upon the approval of statutory authorities. So the class of person operates from enactments and regulations. The duties, responsibilities, or rights that they can operate flow from enactments and regulations, not from their full legal capacity. The individual, man or woman, may stand upon his constitutional rights. He owes no duty to the state, since he receives nothing from there, beyond the protection of his life and property. Now, his rights, his full legal capacity, are such as existed by the law of the land long before the organization of the state. So here the judge is saying that as a man or a woman, you have full legal capacity, and you have this by operation of law alone, not through enactments or regulation. This full legal capacity, it existed by law of the land long before the organization of Canada. That Canada that we talked about here, that's the corporate body. And it says these fundamental rights and freedoms can only be taken away from him by due process of law and in accordance with the Constitution. He owes nothing to the public so long as he does not trespass upon their rights. Again, what is that? Common law, do no harm. Can't harm another. If you do, then you will be held criminally responsible. The judge is stating here that we have fundamental rights and freedoms, and they can only be limited or abridged in accordance with the Constitution Act of Canada. And you saw tonight, through the Constitution Act of Canada, it should afford us the same protection as international law, and that the ministers and the executive powers of Canada cannot point to their internal laws, to their enactments, to justify limiting or abridging our international fundamental rights and freedoms. We saw that Article 16 gave us the right as men and women to decide if we would take recognition as a class of person before the law, and that this right is expressed in the Constitution Act of Canada, 1982, in Article 7. However, through their internal law that they created, their enactments and regulations, they have incorporated us into their corporate body. They have forced us to play the class of person, officer, within the corporate body. We further saw that Canada, when we use the word Canada, it refers to a corporate body, and the powers that are in operation in this corporate body are executive powers. And the Governor General of this Canada, this corporation, he's the chief executive officer. This is what's transpiring in the country.